Hey Tom, how you doing?
I'm doing fine, David. Thank you.
It's great to see you today. Well, Tom, you've been a Texas attorney for how long?
I got my license in 1989. Add up how many years that is. What is that, about 36, 37 years?
Yes, that's the year I graduated high school.
Unfortunately, I was late going to law school.
Yeah, I figured that.
I have an MBA. I spent some time in Tokyo, spent some time working for an insurance carriers council. I was a late bloomer.
No, I think sometimes the late bloomers are the ones that are the best because they have the broadest spectrum of experiences before they get there. I personally see that all the time. Matter of fact, I know quite a few guys who used to be like I know one guy who was a cop. He was a PA, and then he was an attorney, and it gave him kind of like some like interesting. Well, it makes it when you call him dishonest, it's really hard on him. But yeah. So what's your life look like? I mean, you do the lawyering all the time. I hear you talk about Texas law, Texas stuff that you're doing all the time. What's interesting going on in your world?
Well, at this point in my career, um, I am more well. Technically, I'm senior counsel with Daly and Black, which is just a fancy way of saying they're letting an older man, that would be me, basically for matters that we bring in together. I no longer have to worry about, well, did we meet the deadlines and how are we going to get this filed? You're more of a senior position is mainly of a, hey, here's my X number of years of counsel. Usually when I start with a new client and a claim, I'll do a background write up, discuss what the case law is, try to get a game plan. And then, trust me, Daly and Black's got some fabulous lawyers. They don't need Tom Hamrick telling them how to answer discovery or how to take a deposition. They are extremely qualified. But I still stay in touch. I'm not a referring lawyer. I'm a, for lack of a better term, a joint venture lawyer. I just don't want to have any more firms. I've had secretaries, I've had employees, I've had office space. I've done it in different towns. I've done it in multiple towns. David, I'm old or older. I'm tired. I don't want to have a firm. And this is a wonderful opportunity for me to work with a very good firm and they put up with me and still have some relevance without going quietly into the night, which I'm not ready for.
Well, good. I contend that in general that our business in the insurance world is so weird and so complex and so changing that anything we do besides be in this game would tend to be bored with. Like it's just not.
I would agree with that, but I would tag on to that if you wanted to talk about what your highest and best use is, by the time you get to a point where you have the training, the experience, the expertise, whatever, yes, you can go off and do something else, but you're not worth it. Sorry, by and large, you're not worth a dang until you've put in the time, you've had the hard knocks, you've learned from the mistakes. And so it isn't so much of it's so exciting we're going to stay. It's look at you had to climb several mountains to get here. No, I'm not going back in the valley and starting again. At least that's my.
Right. Well, I think that I had a friend of mine explain this to me really well because he knows something about our industry. And he said to me, he said, is it entirely possible that you could have a incredibly large amount of how you have to strategize in your business occur over a very short period of time? Like in your world, the insurance carriers could decide they all want to change the way they write things in these following ways. And they just do it over a short period of time, and you have to change the strategy in which you work. It may mean the law changes dramatically, and you have to modify how you work. And most businesses don't change that much that quickly. There aren't feedback loops that are that fast. Even in technology, it maintains a very definitive path. It doesn't magnanimously change at any one point. to the degree that you have to change everything that you're doing. And he just said, he told me, he says, I think your entire industry is crazy, because he says it's like, he described it, he lives on the Gulf Coast. He said, it's like only going out when there's a small craft warning out and thinking that's going to be more fun than just days when it's just smooth sailing. He said it doesn't matter. He talked about all the people. He just happens to be in an industry where he sees a lot of people in our industry. And he said, he said he said, I wouldn't want to fight with anybody who's been in the insurance industry very long. He says, because they're perfectly willing to pick up new tools to come after you because they're so accommodating with changes. And I think that's true. You remember, like, used to in Texas, I mean, 10, 12 years ago, maybe longer, there was, they could invoke appraisal as a get out of jail free method, because the moment they figured out they did some bad faith, they would be able to just quash it with appraisal. And I think that changed, didn't it?
No. So actually, all right, Texas is difficult. And let's just be honest, every jurisdiction has got its own unique qualities to it. Let's digress a little bit. The practice that we're involved in, from a lawyer's perspective, when I went through law school, I'm not that old, but I am. Look, it wasn't taught. And I would think by and large until relatively recently, this wasn't a subject. It wasn't even a career path. Okay. So what I was going through is, yes, at least on the civil side, you could do mergers and acquisitions. I was a class action lawyer for a while. I started off as a defense lawyer, defending banks. So this idea that the practice, at least from a lawyer's perspective, has been consistent, and then all of a sudden we're in this weird time period. I would tell you that, nah, that's not true. When I was graduating, you had these things called, you could do medical malpractice cases. Most of the insurance defense for medical malpractice, a good number of those lawyers are no longer in business. It's just because the law changed. The law is constantly changing. Whether most people realize it or not, even for a lawyer, you have to retool your business, I want to say every 7 years, let's say. And it's probably 5. And most of us hang on until It's been 10. So if you've been practicing 30 years, you've retooled 3 times. Okay. So this idea that there's this consistent market out there is not true. The biggest change is, look, we've had appraisal in Texas since the late 1800s. I think we're going on 140 something years. There were only a handful of cases before 2009. A handful. All right, a couple handfuls. So when Steve Badger or I say, hey, I used to know every case in this area, that wasn't tough. That was, I don't know, 40 cases, 50 cases. For the average lawyer, you can read that in a weekend. Now,
You don't think Steve Badger just thinks he knows everything?
Look, the definition of a lawyer is a know-it-all. I'm a know-it-all. He's a know-it-all. We get paid. What am I going to do? Pick up the phone and say, Mrs. Smith, I have no idea what I'm doing, which I tell often. Look, it's a little bit more difficult as you move up in your practice area. When I graduated law school, I went and talked to a gentleman who turned out to be my mentor. And I remember, like I had all this stuff going on in my head. And I just remember he has no idea that we changed the rules of procedure. And he was a fine lawyer, but graduated in the 1950s. And I just remember thinking, how can anybody be so out of touch? And the answer is, that's me now. You get to a point where as you rise, you get more and more specialized, and you don't worry about the breadth of what it means to practice law. And I suspect that would be true in your industry as a.
It is. It is. I mean, like for example, like a good chunk of what we do in my estimation firm, for example, is supporting attorneys, whatever they, like plaintiff or defense. Like in the state of Florida, Florida used to be the best place on earth to have an insurance claim, because if Miss Smith got shorted $24,000 on her roof, which is a very big deal for Miss Smith, she could go to an attorney and he could get reasonable attorney's fees to go litigate that. And when they killed completely attorney's fees, except if you lose to the carrier, then they can toll you, which is very weird. That, it's just very weird. If you and I get in a fight with each other and, we go to court, good chances, if you beat me, I'm paying your legal fees. It just, that happens. But no, they changed that. And at the same time, they made the bad faith statute really, really weak. I have to do something like, say, I failed to adjust your claim because you're Jewish. Something like that would be some overt act, is the only way they get it. So what they did was, in just like one day, they basically got rid of about 70% of the defense attorneys. Boom, just like that. In course of it, just a couple of weeks, a bunch of attorneys that were doing insurance claim work just jumped right over to PI. So you have a segment of my customer base which just disappears, just poof, go away. The other thing is, they used to be able to put like all of our early on expert cost into the case, and now they can't. So now it's come straight out of the insured's pocket. So you could see how that would adjust what we were doing a good bit, because that means that there's going to be less of that work to some degree. Now, the backside of that is that, I used to get, for example, personally, I used to get listed as expert a couple of 300 times a year. And there's years where I would do, better than 300 depositions. Just constantly sitting in deposition. We couldn't do that until after COVID, right? Because we didn't figure out we could do it on Zoom, which that's the one thing from COVID that was really cool, is we figured out that we could do this on Zoom, and I don't have to schlep across the country and sit across the table from people. But the interesting thing is that used to, I would do that, and they would just, in Florida, they would just settle the cases. So we never, I would go to court maybe once a year. Well, now they go to court on everything. So if I get deposed, I'm pretty sure I'm going to trial. And so it's just really weird, because I've been just like this year, I've been in trials more than I've ever been in my entire career, just because that's what they do. Because you realize, remember I told you that on the defense side, they lost about 70% of the attorneys, right?
Right.
So who was left? The litigators. So you have all these people, and what's really sad actually is you have all these attorneys in Florida, okay, that have been negotiators. They've been settlers. They've not been litigators. And so we take this very small group of defense attorneys, and they are just dragging these people into court. And, being a trial attorney is different than being an attorney, right? It's not everybody walks that walk and does really well. It's a different world. And so we have all these people who aren't experienced in this area that are suddenly having to get really experienced in this area, because they never had to go to court before. And it's been wild to see. But so I guess what I'm saying is it's a huge change in the business, but it also, like in my business, it affects me, because, used to, I could say things like, hey, I'm going to just take off from, May 15th to the end of June. And now I have to say, but I'm slated for 3 different trials, so I might not be able to go if the trials actually go. And it's just it's just changed my world a good bit. And the other thing is that's been interesting to watch is with I've always worked all around the country. That's just my thing. I like going lots of different places. But the other thing that's been interesting in Florida is I am with a lot of Florida attorneys in a lot of other places these days. So I see them in Texas, I see them in Tennessee, I see them in Kansas, I see them in North Carolina, I see them in California, I see them all around. Okay. And so on one level, it's been really nice, because a bunch of my customer base is now going other places. So I tend to know more about those places than they do when they show up. Hey, Tom, I thought you'd find this interesting. Do you know what, and it may have changed a little bit, but do you know what bad faith is in Connecticut?
No.
Well, if you, the carrier does, if the, and you have to give them notice of their behavior. If they give you written notice that they behaved badly and they're going to change it and they don't change it, then that's bad faith. But if they never answer you, it's not bad faith. So they have to actually agree with you before there can be any sanction for it whatsoever, which I thought was just pretty crazy.
So
But
my thought on that, and you hit a wide spectrum of possible points. Look,
mm-hmm.
you don't build a business based upon the recovery of bad faith. You don't.
Right.
And I don't care if you're in the PI world. I've gone to trial in my entire career and gotten punitive damages one time. And it had to be pretty
Oh,
simple.
yeah.
And now we pled them in every case. It's just you don't build your practice on it. Mrs. Smith doesn't really care if you get bad faith damages or not. And so that's number one. Number two, much bigger hammer is the recovery of attorney's fees. Take
Mm-hmm.
in recent times, the most impactful Texas Supreme Court case was, I think it's USAA versus Menchaca. Came out in, I don't know,
Mm-hmm.
2016, 2017. It was huge. For most of us, it revived the belief that bad faith was still alive. In fact, the Supreme Court went out and said it is, and articulated 5 different sections and blah, blah. And when you read that case, you wondered, wow, it got all the way to the Texas Supreme Court, until you really read it carefully and said, how did it get there? They went to trial and got them tagged for 11, if my memory is correct, about $11,000 in bad faith. Really? You think that they fought having to pay $11,000 in bad faith, that warranted $100,000 or $200,000 in attorney's fees?
Yeah.
Always read the footnotes. And one of the footnotes, it just nonchalantly said, additionally, at trial, through trial, this is back in 2016, 2017, the jury awarded $135,000 or $130,000 in attorney's fees. That's what gets cases settled. So
You're right.
So I'm never concerned about, oh gosh, we're not getting bad faith. I am very concerned if they've cut off our ability to hold the hammer of, look, if you throw me in that briar patch, when we come out of it, you're going to have some attorney's fees that'll make this case look like nothing.
And you're right. And that's why to that point, that's why for years in Florida, we didn't go to court very often, because that hammer was always there. And that made a huge difference. When you took that away, it meant that you lost a lot of power.
Now,
And, heck, I do that in my contracts for that reason too.
realize that in civil cases, the biggest practice, so if you're a young lawyer in my generation coming out and you wanted to go off and hang your own shingle, the biggest practice area was PI work. You'd never get your attorney's fees
Right.
in PI work. There's a
Right.
whole industry. I don't know statistically, but a large portion of all plaintiffs' lawyers at some time were PI lawyers. Okay?
Mm-hmm.
That industry is not built upon attorney's fees. And so now it doesn't have room for adjusters that much. In other words, and by adjusters, I mean public adjusters. They don't exist there. There is no appraisal clause. It wasn't designed to be down and dirty and fast. And if you think about it, if you remember when Steve came out and said, what the hell is going on? What he left from that is the reason why this practice has picked up is several reasons. Number one, we went from the square footage of a roof. Look, when I started, it was, you could do a roof for $4,000. They're small houses. Then it went to $6,000. Now I'm in El Paso, Texas at the time. I remember the guy saying, "You made 8,000. The roof for about 8,000 on it."
Mm-hmm.
It wasn't enough. If we took 40% of $4,000, number one, they couldn't get the roof fixed. Number two, it wasn't worth fiddling with. And so
Right.
this industry grew up with a need to find a more cost-effective way to get it done. And it shouldn't surprise you The same happens when you're dealing with automobile damage in a disagreement. Yeah. Your average PI lawyer does not take a percentage of the property damage. In other words, when Mrs. Smith comes, she says, "I've been in an automobile accident." We say, "Well, go find the body shop of your choice. Don't worry, the body shop will work it out. We don't get involved. Choose your body shop carefully. I don't want to hear later on that your body shop's not doing you correctly. You chose them." And that was 90% of the time got it resolved. There was no money to be made for a lawyer to get in that. And that system was set up that way. It was set up that way. We don't need you. It's just and maybe body damage to a vehicle is easier to assess than whether or not you have some hail damage to a roof. I don't know. But this system was originally designed that you didn't need us and you didn't have us. Okay. Then we started getting public adjusters. And the very first training video I saw for continuing legal education was two good old boys, a lot older than I am today, sitting around. One of them worked for a major accounting firm. The other guy he looked like a guy who hadn't had friends in 50 years. He was a little bit disheveled, but they knew each other well. But they weren't fighting over Mrs. Smith's roof. It was, remember when that refinery blew up and how we had to audit, the loss and this. And I remember thinking that was what appraisers did back then. That's what a PA did. A PA wasn't a person like you or me or the average guy. A PA had to be didn't have to, but was in that era possibly a CPA. Working for when I was growing up, we used to call the Big Eight, or they went to the Big whatever.
Right.
Okay. So, I mean, no, this is not is it damaged? We have to count the beans and figure out what's owed here. That practice may exist, but when the PAs that I'm meeting now, the appraisers that I'm meeting now, do not match that picture of what the old timey appraiser was.
That they would agree.
Okay. And so to a certain extent, and I'll pass it to you, but I want to make one more quick up.
No, go ahead.
We're living in the wild, wild west. You hear that all the time. But I've got news for you. Everybody's gonna have to step their game up. Look, every lawyer looks across the fence, the proverbial fence, and say, "What's going on in your practice area?" Okay. And in the old days, when you looked across over the property damage, you just said, they're looking now. Venture capital's coming in looking at you guys. Venture capital's coming in taking a look at the PAs. The houses have gotten bigger. The roofs are more expensive. Geez, I just dealt with a residential property where it's a $2 million claim. It's not a fire claim. It's a hail claim. $2 million. Granted, it's a beautiful home, but $2 million? Now, last point. Lawyers have always been and always will be the least cost-effective means to resolve. Least cost-effective. We are the last house on the block. And if we become the only house on the block, you're not going to hear lawyers complaining. PI is a great example. Personal injury. Mrs. Smith gets in an accident. Does she need a lawyer? No. But do they call one? And I spent an entire career saying, "Mrs. Smith, we're not going to do anything in the first 6 months that you couldn't do yourself. We have to go get medical records. We have to, check in. We've got to talk to the insurance company. We've got to tell them what's going on." It's not any different than when a painter gets called, "Hey, I need somebody to paint the interior of my room." Well, you can do it. I'm not saying it's going to look great, but there's highest and best uses. But this industry will rue the day, and so will the insurance company, when they make it so that appraisal never works anymore, where PAs don't have a whole bunch of power, if you think about it.
They don't.
I'm imagining the phone call goes, if I put the following people in a room: a roofer, a lawyer, a PA, and an appraiser, and this is all pre-litigation, who do you think the most powerful person in that room is? The contractor calls up and says, "Hey, look, I'm working on the roof." The guy says, "We got it. We've already inspected it. Go away." Okay. The PA then shows up and says, I've got it inspected. Here's our thing. They say denied. Stop calling me. The lawyer writes a letter. Geez, don't ever hire that. Right? What do you think he's going to do with the lawyer? He's just going to put it in the file. You're called a paper tiger. We're not afraid of you. The appraiser comes in and he doesn't even call the adjuster. He basically says, shut up. I'm the appraiser. The only other person I'm talking to is the other appraiser. That's your most powerful person in the room. And it doesn't mean these other people don't have a purpose, but as far as a potential resolution, I would argue appraisal is a pretty powerful weapon.
Yeah, I agree. But at the same time, the attorney still has more tools in their quiver as a rule than anybody else. And so, like, there's a lot of appraisal that I handle and that my office handles that's behind an attorney because it never would have gotten there without the attorney. You know, I have a bunch of files in Kansas right this second, for example, where there is an appraisal clause, and the moment you file appraisal, they send a new engineer and a new adjuster and say, we haven't finished adjusting the claim. We're not ready to go to appraisal. So, you know, you're going to wind up with an attorney there to get it there. I mean, that's where you're going, because you're going to have to compel them in that way, because the attorney's the only one that can make, the only contract officer, if you will, that can basically go and say, hey, you're screwing up. You're not following the contract for insurance. And I see that model coming more and more and more and more and more, where appraisal is a tool behind an attorney more than it is anything else. Because, you know,
if that's,
and I mean,
David, if that's the case, then everybody else has lost the battle. I mean, what you basically,
well, that's the way it was. That's the way it was in Florida a lot of years.
Well,
because we used appraisal to set the value of the loss so that you could carry forward with the case.
Right, but you didn't need a lawyer to do that.
I agree. You didn't need one unless there was other issues. But no, I mean, I agree with you, and I think it's always gonna change. But the other thing that's true is that Miss Smith, if she doesn't have a PA, she's probably not hiring an attorney. She's probably not hiring an appraiser. She's going to the attorney.
Agreed.
Today. And, you know, I mean, that's, you know, at the end of the day, I mean, that's where you play. I mean, what's the strangest thing you're seeing right now? The thing that makes you scratch your head?
There's a bunch.
I know that's a big ask because we do insurance work.
Let me just go through probably not the strangest, but some of the more repetitive things. There's this idea you just described it of, you've asked to go to appraisal, we're not ready to go, we're not going to go. There are two ways to look at that in Texas, and this is just my personal opinion. I'm not giving legal advice on this.
I understand that.
Number one, while I'm not a fan of an open or an empty chair appraisal, in fact, for years I said that wasn't possible, there is now one case. Now, that's not a whole bunch. One case does not make a great battle wagon, all right? But it's at least it's a case. It's the only case that I'm aware of that says fine. If they don't want to participate, go down there and do it by the book. You know, advise them, do the Babe Ruth thing. I'm heading for that fence at this time on this pitch, and we're going to ask this court to appoint an appraiser. I mean, an umpire. Take the award. The antithesis of that is, and this is important, earlier in the year we had a case called Rodriguez. And what Rodriguez basically said, and I'm just going to paraphrase, is that if you go to appraisal and they say, we're not going to pay the award, you hire a lawyer, you get at a certain point in the case, and they finally say, here, you know what, we're going to pay the entire appraisal award and all the penalty interest, but we're not going to pay attorney's fees. As long as they paid the interest and the total award, you cannot recover attorneys. Now, think about what that sets up. It sets up we made you spend a lot of money. This is going to be we're going to ruin this industry. You know, you're going to force you to hire lawyers, and no, they're not going to be able to offset it. And does it make a lawyer happy? No, but they're still going to get their 40% or their 30%. All right. So It's not good for the industry.
You know what I think is going to happen is I think somebody smart is going to write an insurance policy that's a not an insurance policy per se. They're gonna like I used to have a policy. Let me just give you an example. When I used to do a hurricane deductible, I used to have a policy that my broker got me, which was a policy on my deductible. So if I had to use my deductible, I had a $150 deductible to spend to take care of my $22,000 deductible. Okay. So what I think is going to happen is somebody very smart that can work it out actuarially is going to figure out that they should that a that a homeowner or business owner needs to have litigation insurance. I mean, if you think about it, my E&O coverage, that's really part of it, isn't it? I'm really prepaying for them to pay for my attorney should I have an E&O claim, right? Same basic concept. I think that's where we're going because as you said earlier, if Miss Smith has a $50,000 claim, no attorney wants that job because she's never going to be able to take care of her issue because of the amount you have to take out of that claim, right?
Unless the lawyer can recover on behalf of Mrs. Smith attorney's fees, in addition to everything else.
Right. And I also think that what's going to ultimately happen is, if you think about it, if I make a law that says that you can't get attorney's fees when you work an insurance claim, I've really created what I refer to as an anti-consumer statute, if you will. Okay. I think at some point, attorney's fees are going to have to go back into the mix on the regular because, what do we say? An insurance claim is a contract of adhesion, right? So in so much as that's true, the carrier holds the most power, don't they?
To a certain extent, they still, in theory, would need to get some sort of approval through whoever the insurance department is of the given state. And we used to have that part settled. We used to have standard policies, which we no longer have. But yeah.
I have a question for you. I've said this a lot here lately that I wanted to, we have these people, a lot of people that do training for appraisal and umpire work that will commonly say that appraisers and umpires operate with impunity. They have no liability whatsoever. And I personally disagree. I think that if you hold yourself out as a professional in any area that you work, I think you have liability. And so I've reminded them that they're on the menu. And I've seen it in Florida recently. I'm seeing it in Tennessee. I'm seeing it in Michigan, where the behavior of a panel is, where people are going after E&O or going after setting aside an appraisal award because of their behavior and going after them for their behavior. And it may be in some cases, I've seen them just go after one or the other, just go after the umpire. What do you think about that?
Okay. So it has a couple of caveats. Number one, it depends on what the cause of action is. For instance, an appraiser is simply an individual appraiser or umpire, mainly operates in the area of, this is my opinion. Okay, an opinion cannot be fraudulent. It's hardly actionable. You hired me to give an opinion. Now, fraud, accident, mistake, lack of authority, those are ways to set things aside. But this idea of, well, I think, we had an appraiser get sued because he came back and said, I think it's going to cost blank millions of dollars to fix this thing. And I say, well, if that's his opinion, well, we think it's a crappy opinion, or we think he had an agenda with that opinion. There's no such thing as a fraudulent opinion.
Okay, I agree, except for one thing. If you would agree that the principle of direct physical damage and the principle of like, kind, and quality are two principles that are baked in the cake, right?
In theory, yes.
Okay. So if I look at a file and I absolve and I decide I'm not going to do one or the other of those, let me give you an example. It'd probably be helpful to give you an example. This is an actual example. Okay. insured has insured gets 3 plumbing leaks the same day. He calls an attorney, he calls a plumber and says something's wrong. You know, he thinks maybe got a pressure problem or something, just something's wrong. The plumber shows up and says, "Oh, you've got faulty PEX." It was that one from like 12 years ago where they did the wrong formulary, and it just, when it fails, it just fails all at once. He says, "I can't do anything about it. I will have to replace all the PEX piping." And this guy calls his carrier and says, "I got to get my plumbing replaced because I mean it just failed, and we got no water. We need to get a place to stay." And they told him to pound sand. Well, he wasn't independently wealthy, and he couldn't go take his 5-member family and put them in a hotel somewhere for any great amount of time. So he called the plumber and he said, "Hey, could you give me a temporary solution?" And the guy says, "Yeah, that'd be like 10 grand. And he says, "But understand, when it gets to be like 80 degrees outside, your cold water is probably going to be like 100 degrees." And he said, "It's just a temporary solution." So he ran it through the attic. I said ultimately that he D.R. Hortoned his house. So just follow me here. So it gets given to a PA. A PA gets them to admit some damages. It goes to an attorney. It gets pitched to appraisal. The appraisal comes along, and the umpire that the temporary plumbing was like, kind, and quality to the plumbing that was went through the slab. That opinion is complete bull, because it's not the same. And anybody can look at it and be like, that's not the same. It was called temporary for a reason. It was called temporary by it even says it on the invoice from the plumber, and he basically writes in it, "This is not a final product because of this, and this. It's not designed to stay there for years and years and years. It's a temporary solution." So this guy awarded the temporary solution as a permanent solution. That wasn't an opinion that he screwed up. That was a factual violation of direct physical damage, and more specifically, like, kind, and quality. Everybody agreed the plumbing was gone, but he agreed to replace it with something that didn't make any sense.
So you have a couple ways of approaching that. There's some rare language that basically says that if an appraisal award does not accurately reflect the damage or the cost, blah, 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 that it can be set aside. It's rare. A better way to get something like that set aside would be to say, look, it's a fact that these two don't match. Okay, it's no longer an opinion. Either the umpire made a mistake. Let's give him the benefit of the doubt. All right, look, if you mistakenly believed. In other words, I don't have to call you a thief. You made a mistake. Oh, it wasn't a mistake. Okay, now it's fraud. Fraud is you purposefully. And then I would have to litigate is there are some things that are no longer, what's the dividing line between, it could be this, could be that, could be this, of this is not that, ever.
Well, in this particular case, this particular umpire said that's how my plumbing's done. It wasn't how his plumbing was done.
So he was.
I assure you,
he was just mistaken.
I assure you, he didn't have plastic piping. So he made a decision that was irrational based on base logic by lots of professionals. He violated. Like, there were 3 professionals that all had agreed on this, that this was just a temporary. It would have been the equivalent of putting rolled roofing on your house because your shingles had gotten pulled off, and then calling that the not being a temporary solution. It kind of like that. Incidentally, by the way, his E&O coverage paid out $78,000 3 days later in that case,
right.
Because and what was actually more funny about that one than anything else is the E&O coverage went after the carrier, because the carrier had some other machinations in this. The carrier had, in the process of getting him appointed, oh hell, I'll just tell you the rest of the story. It's kind of interesting. It's terrible. It's one of the most embarrassing things I ever did. My appraiser was working this file, okay? And I was familiar with the file only because I found it interesting. And so I'd seen the property. I had consulted with my appraiser on it about what was appropriate. I'd even talked to a plumber that I know about it. It was just interesting to me. And the umpire and the two appraisers had a meeting, and the umpire had basically announced at the meeting before he ever saw the property, well, I don't see what the big deal is. That's how my house is done. So I don't think you should expect to get what you're asking, is what he told my appraiser. And I was like, wow, that's something, right? I was aggravated about it. So now keep in mind, I don't know anybody's attached to this at all. I don't know who's attached to it. It just was in our office. So I don't know anything about it. So I jump online one night and I just write this and I say, look, just theoretically, let's talk about this. What do you think about this? And I sum up kind of what it was without telling the characters or it was a real claim or anything. And about 2 minutes later, a PA comes on and says, that's my file. I'm like, oh shit. They're chattering about it. And then the attorney that has it goes, that's my file. And it gets like about 30 comments on it really quick. And I just go delete. Because now I'm like, this was not what I had planned, right? In that 3.5 minutes that it was up, the carrier appraiser screen captured it.
Okay.
He contacts the panel. No, he sends it to the umpire, and the umpire says, I'm bowing out. I'm not going to do it. So now they don't have an umpire. So my appraiser comes back and says, well, why can't we just get somebody else since this guy resigned? He says, no, we're going to go court appointed. So they go to court, and the carrier says, we've already paid this guy, so we want this same guy that resigned. And he says to the carrier, I will do that as long as you will sign an agreement that I hold no liability for that you'll protect me from all liability from my award, because he was scared of the attorney. So the carrier agreed to that, and he became the the umpire again. And about 5 minutes after he got reappointed, he ruled on it. And then I already told you that the E&O coverage had to pay for it, right?
Right.
But remember what the carrier told him?
They would cover it.
So the carrier ended up paying his E&O coverage for that. It was kind of fun. But my point is just simply this. I believe that we're going to see more and more and more and more and more where appraisers and umpires, because they're not engineers, they're not opining. Okay. I think that they're not opining. They're not giving an opinion. They're giving an opinion that's actionable.
I don't follow you. What's the difference?
Okay. What's the difference?
Yeah, opinion is
okay. So, well, like, let me give you an example. Okay. If I'm an engineer of record, then I'm the engineer that's carrying liability, aren't I? Like on a project.
Sure.
On a project.
Sure.
If I'm the engineer of record. If my stuff's going to permitting and I'm holding liability. If the building falls down or something's designed wrong,
right,
I own it.
Right.
Okay. But in the insurance world, we don't usually have engineer of records unless you're on a file I'm handling. Because I like the guy that has liability, but if you're just a regular engineer on an insurance claim, you're just opining. You're just giving an opinion. You have no liability because it's just your opinion. What I'm saying is that somebody smart, some attorney somewhere is going to do this, is going to make it where that panel is playing sudden death. And since they're playing sudden death, they hold liability. I think that's coming. I've seen it in places, and I think it's going to see it all over the place.
My concern is that there are some circumstances in which where science applies or mathematics applies, or look, I'm hiring an engineer to apply these formulas and properly design something. That's a far cry different from, hey, is this functional damage? Or what is the proper method of repair? If these things were not opinions and they were scientific certainties, I wouldn't need an adjuster. I wouldn't need a PA. We would look it up in a frickin' book and we would award it. The three things that an appraisal panel does is it damaged? What's the proper method of repair? And what's the going rate in the market? And I know all three of those are opinions, because if they weren't opinions, I wouldn't need you people. We'd open a book and look it up.
Okay, but like, let me give you an example. You see this crap?
Yep.
Okay, that's an appraisal where the appraiser was required to be disinterested. So the $4 million award that they got, the carrier argued that the insured's appraiser wasn't what was it crap why am I having a
I know.
they weren't unbiased. It was a biased appraiser. He
Right.
was the appraiser was working for the insured and was trying to advocate for the insured. So they get this $4 million award. The carrier goes and litigates that. They throw out the award and they send it back to appraisal. They send it back to appraisal and it comes out at $55,000.
Oh, geez.
So now the plaintiff side is working on doing the same thing so that they can have yet another appraisal. I think it's crazy. I think it's just utterly crazy. I just noticed a lot more of this crazy going on. That's all I'm really saying. But
there is case law that basically is at the appellate level where they've overturned something, and the appellate court says, "Oh, we're not sending this back to appraisal. You get one shot at this, and one shot didn't work. Then just try it." I think that was the Wells opinion. Out of Dallas. It's discretionary, but how often do you think appraisal works, or do we just hear about all the bad ones?
I think appraisal actually works a tremendous. I think appraisal works often, gets more to a more realistic number than I think that they get to in litigation. Because if we have three legitimate humans that are capable, we're usually going to come up with a pretty good solution as long as that panel's not polluted in some way. There are plenty of times where the panel is polluted in a way that it's going to really, really affect it. You know, I have one right now where, you know, one of the appraisers has an irrational opinion. Okay. I mean, it is irrational. It doesn't reckon with the fact that this is a $7.5 million home, that every single thing on this home is really, really high end. It doesn't rationally, you know, I mean, he's turned his back on a lot of things. So, I mean, it's going to feel really bad for him because the award he's going to get isn't going to feel rational to him because he starts in an irrational place. You know, what does concern me, Tom, about appraisal in general is it does concern me the level at which the carriers are often running their appraisers at this point. It concerns me. Hey, it concerns me when I see PAs and attorneys running their appraisers also.
Okay.
I would say that attorneys are excellent at saying, "Go do it and let me know how it goes," you know. But PAs sometimes are not.
So I'm of two minds when it comes to the types of stuff that you just described. Where one of the appraisers is just for whatever reason their bread's buttered on a certain side. They're looking like this.
Mm-hmm.
Number one, the fact that you should be able to get an umpire that should be able to rationally see around that problem, to me, would be important. Now, I know everybody in this industry wants everybody to have subject matter expertise. Subject matter expertise is, hey, don't pick an umpire that has no idea up from down. And I would say that perhaps in some cases I can see the advantage, but I have two questions to ask you. Number one, where do you think the people with subject matter expertise come from? Where did they get their training? And it's more of a rhetorical question because you might have got it on the insurance side. You drank that Kool-Aid. You may have got it on the policyholder side. You drank that Kool-Aid. I don't want my umpire drinking either side of it. I want them to be a blank slate. If I were an appraiser, I'd want to say, hey, give me an umpire that will pick the best answer. You get a highly trained umpire, highly trained. You, for example, how much am I going to be able to convince you? You've got years and years and years of technical expertise. The mere fact that you were chosen as the umpire, you brought with you, rightfully so, but no one's going to dissuade you of 30 years of experience.
But at the same time, even as the umpire, I need to say, hey, if I'm not sure about this, I may need a subject matter expert to create some report or some inspection for me because I'm not comfortable with my position.
But 99% of the time, you are very comfortable with your position.
Yeah, I am. Okay. I am. I'm also what I have a problem with a lot of the umpires in general is that they basically sit on a file for 4 months and then issue an award that's splitting the baby that has nothing to do with rational about the loss. I always tell people, don't hire me unless you want me to call balls and strikes, because I'm not splitting the baby. I'm not going to do it.
How many, if I put in a room people like you, and by like I mean years of experience, dedication, has handled big claims, and I put you all in a room and gave you a test, are you all going to test out the same as far as views, opinions, qualifications?
We're not going to test out the same, but we're going to have very similar. We're going to have similar views. They're not going to be perfect, but they're going to be similar if they have a lot of experience.
And so really what if you're all pretty much the same, or there is a category of umpire that has, I don't care if you, I've always thought by the time you got to be regularly appointed as an umpire, you've transcended both sides, right? So I've always said a
Yes.
good umpire is a good umpire is one that the insurance company says, I don't have any problems with him, or I don't have any problems with her. And it doesn't matter who's picking them. Now, if you're trying to shave off some points here, I'd rather have my guy show up as the umpire, which I've always detested. It's like, what's wrong with a fair tribunal as opposed to, no, I kind of want to have my finger on the scale a little bit, or I'm going to really stick it to him. That's got no place in it. Now, that sort of gamesmanship exists, and I would be naive to say it doesn't, but it's not what I'm after. And so one of the first questions I ask is, do people really want a fair system? I'm not hearing it in a bunch. I get called. I get called up, hey,
Oh,
can you get me a good umpire? Well, what the heck's a good umpire? One that sings your song, or do you want one that calls balls and strikes? Because when they say good umpire, they're not talking about balls and strikes. Go ahead.
right. And the you're right. And there are people that only buy. I asked a guy the other day on an appraisal. I said, my problem with your list is your list is full of just ringers. These guys are not gonna. These guys, if they were to write an award, if they showed up on a claim that was really, really screwed up and it's really just seismically bigger than what it was originally adjusted at, I said, these guys aren't going to be able to do it because of where they come from and how they see things. They're just not. I find the whole process to be interesting on that level, just because, I mean, I do like appraisal because it brings out the worst characters. Like, you can find the worst characters there. You can, because I mean, they have to take all their clothes off and just show it right there. I have a guy who said to his opposing appraiser, yeah, I want all the windows. And his opposing appraiser says, there's no damage around the windows. Why would you want the windows? That's stupid. And the opposing says, well, I'm getting the windows and I'm going to the umpire and I'm going to get the windows. He says, well, I need to get an expert to look at it. The other one said, I need to get an expert to look at it. He says, you're not allowed to get an expert to look at it, because he's just, I mean, he has a terrible position. So he's just trying to browbeat this guy into not being able to fully investigate the loss. And, I will tell you this, Tom, what I have noticed more than anything is one of the reasons why we use appraisal a lot, I think, is because up until the appraisal, nobody's done a complete claim investigation. Like, they've just thrown some money, they've just thrown some stuff against the wall. And like I'll give you this simple example. We had a loss where it appeared this lady had some damage, but the weather didn't make sense. So the carrier in this case had written a legitimate report based on the fact that it didn't make sense. I understand what they did. They really didn't do anything that wrong. But what I did was I did two things. I hired myself a meteorologist as the umpire, and I went and banged on like 20 doors in the neighborhood. And I asked them if they had an insurance claim relative to this particular loss. Turns out 70% of them did. Okay, that's something. And then I get the meteorology report, and the meteorology report tells me exactly what happened on this property. And suddenly the damage that was attested made sense. And at the end of the day, though, nobody could be mad at me because I did a legitimate claim investigation, and I found the truth. And it was, in that case, by the way, I got 3 signatures, which was nice. But I mean, had somebody done that before, it might have been a different outcome.
So here's my thought, and these are, one of them's a pet peeve, and one of them is just a jurisdictional.
Mm-hmm.
As I listen to you in a broad brush fashion talk about what you did, it's always been my position that An appraiser does not, in Texas, when you walk up on the roof, you got both appraisers, let's just say. One turns to the other and says, "Do you see any hail damage on this roof?" And the guy next to him says, "Oh, you mean hail damage from this particular date of loss?" And the guy says, "No, that's not what we do in Texas. Let the lawyers figure out, do you find any hail damage?" Now, there's a big debate. I'm telling you, and there's even a recent case out of the Dallas Court of Appeals, which is contrary to an earlier Dallas Court of Appeals. But I believe if you read State Farm Lloyds versus Johnson, it basically is read to say, hey, that's coverage, liability coverage. That's a determination you're not making. Stick to, is it damaged, not when did the damage occurred? How much is it going to cost to repair based on the proper method of repair? Now, that may vary, but at least my position always been is in Texas, don't do that. It gets worse
Right.
because under farmers policy, at least the one that came in 2011 or so, where the same two guys get back up on and he's chastised his buddy over there. He says, "Okay, do you see any damage on this roof?" He goes, "You mean hail damage?" The guy says, "No, this is a farmer's policy. It's just damage. We're not supposed to even distinguish if it's hail damage or bird crap." And that's an unfair reading of the policy, but
Yeah, I got you.
we've had that particular problem. Then there was something else that I said that was my pet peeve, and I probably just said don't talk about it. Look, the thing I don't like about appraisal, the things that I've been trying to smack appraisers in the head, which I think you're very good at, by the way, which is
Thank you.
number one, leave your ego at the door. Number two,
Mm-hmm.
I never saw Fight Club, but there are some Fight Club type rules in appraisal. We don't make rules. How many times you say you can't go get an expert? Really? I mean, or I want you to tell your homeowner that they have to produce every document. No, you don't have the right to produce. These are things appraisal, at least in Texas. I always picture it this way. It's the 19th who's one of the contractors, and I got Leroy, who's the other contractor in town, standing up on the roof going, "Bubba, you see any damage?" Yeah, no. They know each other, or it may be that the insurance company gave up on the Leroys and the Bubbas, and they sent their own field adjuster out. He took the train down to the little town. It was not a big deal. It wasn't a big deal. Everybody called. Nobody was trying to make a bunch of money. They both knew if they were the appraisers, neither one of them was going to get the case. They knew what the going rate in the town was. These were relatively straightforward. Now, that's not to say you didn't have fights at the commercial. Yes, if something blows up, if trains do this or whatever, the major commercial stuff, yes, we expect those to be fight. But Mrs. Smith's house, it was nothing. And that's why appraisal worked. And there wasn't enough to get a lawyer involved because you weren't fighting over anything. And guess what? When you're not fighting over large amounts, lawyers don't get involved. And guess what happened? It's settled. Now, you could argue that during that time, the insurer, the insurance company, reigned big, large, and in charge. Did they steamroll people? Probably. I don't know. People act like whenever we badmouth an insurance company, that you can't do that. These people have always had a reputation of being great. I think there were articles in the 1930s that talked about insurance companies like they were the scum of the earth. Don't think we didn't
Mm-hmm.
get the laws passed because the insurance companies back in the 60s were thought to be great people. Don't think the DTPA got passed because somebody woke up in a bad mood and decided that we need Deceptive Trade Practices Act.
I have a reason why I know what you're saying is true is, you had that first fire policy that came out that started this whole process, right?
Right.
But within 50 years of that coming out, there were state legislatures who made laws about how you adjusted fire claims. For example, it's been baked in the cake a long time that on a fire claim, you get RCV in Florida. There is no holdback. And that's so I mean, there was, I guess what I'm saying is early on you had these issues. But I think, Tom, to close it down, I mean, I just think that what we do is interesting. And I think
Yeah.
I think your perspective as a senior in this game is so valuable because you've seen a lot of different imaginations and respect people a lot who can see kind of like pattern recognition to see where things are going. And I always hear you when I see you speak, you're always good at seeing what's been and what's going to be. And I think that's just really, I think it's phenomenal.
Yeah, don't be in a rush to be the old wise guy. I'd rather still have been the young buck. And thank you. But let's just be honest. It's easy to sound like you know everything. David, every week they come out with new cases. Whatever I'm pontificating today could be wrong tomorrow, which is how you and I kind of got on this. You made a statement about all of us. I forget what your quote was from a couple of days ago about, but essentially we're all just doing the best we can with what little information we have. And the answer is it's a moving target.
Yeah.
What makes you a success, at least in my eyes, is are you trying to do the next right thing? Right?
Mm-hmm.
Okay. Are you trying to be fair and honest? And those sorts of qualities, you sound, oh, yeah, everybody has that. No, everybody doesn't have that. Okay. And I'll leave it this way. At the end of the day, I don't care if you're a lawyer, an appraiser, an estimator, or a PA, your first and last duty is owed to Mrs. Smith. Every time
Mm-hmm.
you do something, it's not, hey, I'm going to make more money if I do this. Or if I could screw that guy a little more. What you have to ask yourself is, what does Mrs. Smith want? And I got news for you. Mrs. Smith doesn't care if you come back and say, I got $800 a square. Mrs. Smith just wants to know that, did you get me enough money so that the job could be done correctly? Not make the contractor rich. Or I showed that guy and we're going after him. They just want their property fixed. And I think everybody loses sight of that. So anyway, and
I agree.
the final thing, David, I spend more time telling people they don't need to hire me. And because when you do hire a lawyer at the end, nobody's ever happy. You know, the one thing a lawyer can never tell a client is the same thing a funeral home director can never tell a client. We hope to see you again soon. Okay? Nobody
Mm-hmm.
walks out of it going, man, I am so glad I had a lawsuit. Okay? Yes, we do important work. Yes, you do important work, but never lose sight of, look, we're in the service industry and it's not about us. So kumbaya.
Yeah. It's like I tell my carrier on my claim. I'm like, I don't want to sue you. I don't want to sue you, but I will. I just need you to understand that if we can't get this done, will. And that's just, I always feel sorry for people in that position because the day I have to call you, I'm deciding to spend a tremendous amount of money on my claim. I'm deciding on a hardship, and I think it's a manner of cruelty that's it's pretty darn rough. But I do have hopes. I do have hopes that we can get back to reasonable attorney's fees because, like reasonable being that they're paid during the claim if you are successful. I think that's
That would be nice.
because I'm about fair dealing. It's just fair dealing. I don't want anybody to have an advantage. I just would like to have fair dealing. You know, we do get that sometimes.
It all works out. Well, I wanted to say thank you for having me on. I'm not very good at this technology thing. So
I think you did great. It's good to see you, and I hope we can do this again. Okay.
sounds good. Thank you very much, David.
Thanks, Tom.
All right. Adios.